Judge, we ask you to deny the request put forward by the plaintiffs for an injunction for several reasons. The first of which is that what the district is seeking to enjoin goes way beyond the purview of para. What we've seen in the city of Detroit, and the plaintiffs are right to say that this began on April 30th, 2015, when teachers from the Detroit Federation of Teachers called in, used a personal day. Everyone knew it was going to happen before it happened. There was no indication of that as being an unauthorized work action. And they went to Lansing under the leadership of their then president, Steve Kahn. In Lansing, they put forward their demand that Governor Snyder withdraw his proposal to turn DPS into two separate school districts and to continue to try to privatize and charterize education in this city. That action caused Governor Snyder to withdraw that proposal. Shortly thereafter, President Kahn was removed from office as president of the DFT. He was removed from office by a trial conducted by the current executive board, and he has not since been placed back in office. His appeal is still pending. He holds no official office now. However, that experience for the teachers of going to Lansing and understanding that they had the political power to start building a social movement that could end the takeover of the Detroit schools and their continued assault by the governor of this state, that lesson stayed with the teachers of this city. And so, in November, when Governor Snyder seized on the opportunity to put his plan before the Michigan legislature again, because he believed that in the absence of President Kahn being head of the DFT, he could get away with it. And teachers who had gone through that initial experience began calling in sick and taking action that was political action. It goes well beyond the scope of their contract. It goes well beyond the subjects that fall under para and are part of an ordinary strike procedure. The actions of the teachers, to quote para, do not fall under the purpose of changing employment conditions, compensations, or the rights, privileges, or obligations of employment, except as those issues are covered by the attack on public education that was initiated 17 years ago with the first bill putting into place of an emergency financial manager and continue to this day. The court has always treated political action by employees to fall in a separate category. And we'd like to bring the court's attention to a case which I think is dead on point. It's Jacksonville Bulk Terminals versus International Longshoremen's Association, 457 U.S. 702, 1982. The court held in that case that an employer seeking to enjoin a longshoreman's strike, the nature of the strike, the precipitator of the strike, was the longshoremen wanting to protest the Soviet Union's invasion of Afghanistan. There was nothing in the collective bargaining agreement speaking to strikes conducted for that political protest purpose. And as a result of that, the court held that since the issue prompting the strike was not one to be first arbitrated under the contract or covered by the collective bargaining agreement, that strike could not be enjoined. This falls completely under that aegis. But it goes beyond that, Judge. Because as is clear from a whole line of civil rights cases in which government officials in Alabama and Mississippi attempted to enjoin marches of civil rights protesters, the courts have held consistently that when a people have no access to democratic procedures and rights, they are entitled to use whatever measures are available to them to bring their grievances forward and to petition their government. And in the city of Detroit, Detroit teachers do not have the power to elect their school board. No one who lives in Detroit has either the right to elect their school board or to even have a mayor and a city council that are provided and fully charged with the responsibilities of running this city. In the absence of that, of any democratic procedures being extended to the teachers and to their students and to this community and to the parents, it is more than justified that the teachers, that the parents who support them, that the community that is overwhelmingly behind them be allowed to protest, to bring their grievances forward in the only manner that they can in order to receive any kind of democracy. And that's through the process of building this movement and engaging in the actions that the teachers have undertaken. The claim, as I understand the position of the plaintiffs now, is that while they say that they are not interested in conducting a witch hunt, they are asking that this court enjoin Steve Kahn, who is a Detroit teacher and who is not a union officer at this moment. Steve Kahn represents the will of a lot of teachers in this district. He was elected by a majority vote, and when he was removed from office and there was a union meeting to take action to decide whether or not to uphold the executive board's decision, a majority of people present at that very large and very boisterous union meeting voted to reinstate President Kahn. But that has not happened. The fact that Steve Kahn presents himself, defines himself as the last elected president of the DFT is a factual statement that cannot be disputed, since there have been no elections to fill the position of presidency since his removal. He represents the teachers because his sentiment, his aims, his objectives, his love for his students, for this city, his understanding that the schools will never improve so long as the democratic rights of the people of Detroit are withheld and eliminated. He understands that under those circumstances, it's necessary for teachers and for the community and students to mobilize together to fight to save public education in this city and for the improvement of the schools. President Kahn, who is no longer an official in the DFT, is being witch hunted in these proceedings. The only organizations that President Khan can speak for as a representative are Strike to Win Committee and the Coalition to Defend Affirmative Action, Integration, and Immigrant Rights and Fight for Equality by Any Means Necessary, BAM. Those organizations do not fall under the scope of PARA. And to limit either Mr. Khan's right to be associated with those organizations or his free speech rights requires going well beyond the scope of this hearing. If the district wants to show that their request of this court to enjoin Mr. Khan as an individual is a legitimate request, they have to tell this court what the compelling state interest is that they are standing on. They have to show that what they're asking this court is narrowly tailored to meet that objective. And we think that there would be no way, Judge, for you to make a decision on any of these questions without first having a factual hearing in which it's possible for Mr. Khan and others to put forward proofs. The truth of the matter is, and I want to just add an addition to the list of teachers who've been cited in this request for an injunction that make clear how arbitrary and how unfounded any of these charges are. One of the teachers cited and named is Erica Jones. It is said that she called into work on January 5th, which she did not do. Her school, Cass Tech High School, was closed by the principal long before she had even the opportunity to call in sick. So why is Ms. Jones on this list? She's on this list for the same reason that Steve Khan is. She's on this list because she did an interview. She spoke out. She exercised her First Amendment rights to criticize E.M. Early, to criticize the district's policies, to criticize Governor Snyder, and for that, she is being dragged into court. And I understand the district's position that they are deferring right now to ask for an injunction on the individually named teachers that they're citing. But they know full well that for any teacher in this state who may be seeking employment, to have their names listed and not withdrawn from proceedings like this makes it much more difficult for them to get employment other places. They know that just the naming of these individual teachers constituted a punitive action. And in our view, Ms. Jones, Mr. Khan, and the other teachers that are named in this lawsuit are protected by the Whistleblower Act, because all they did is tell the truth. And for telling that truth, the district has punished them by naming them on this lawsuit, and Mr. Khan in particular by attempting to continue to try to get this court to take the illegal action of depriving Mr. Khan of his First Amendment rights to express his views and his First Amendment rights to free association, to be a part of organizations that are committed to telling the truth about Mr. Early, Governor Snyder, the takeover, the loss of democratic rights to the people of Detroit, and the atrocious, shameful conditions of the schools. We think that, Judge, there is nothing that's been presented to you thus far that would warrant the action against Mr. Khan or any of the other teachers that the district is seeking. We think any attempt by the district to enjoin what they call advocacy organizations, and included in that list RBAN and Strike to Win Committee, not only falls out of the purview of para, but again means an attempted limitation rights on free speech for those organizations. Logically, what their position is, if I can just finish this point, Judge,
Okay.
is that if any preacher in Detroit got up in a pulpit and he had teachers as part of his congregation, and he said to those teachers, I advise you to continue your protest action, to continue fighting for your principles. That church and that preacher could be enjoined for allegedly causing people, inducing them, encouraging them to take action. And that obviously is well beyond the scope of the law and an absolute violation of both the Michigan State Constitution and the federal Constitution. So Judge, please, I'm sorry.
Thank you.
Can I just, oh, I thought you had a question. I'm sorry, Judge.
No, I was thinking that you made a wonderful opening statement that I'd like to actually move forward.
Okay, thank you, Judge. We appreciate your time and consideration in this matter.
No, you're not going to do that. You can tell her later, okay? I have a couple of questions for the plaintiff before we figure out what else is going to happen today. Could you tell me how, what did I find these? What is the basis for your seeking an injunction pursuant to para against, by any means necessary, what's the other one called? DPS teachers fight back and Detroit strikes to win?
The basis for that, first and foremost, Your Honor, and I think what may have gotten lost in this is that both Mr. Khan is a public employee, he's a teacher of DPS. And para specifically not only prohibits strikes, but it also limits the First Amendment rights of public employees with respect to their freedom of expression when it comes to expression or communication that interferes with the full, faithful, and proper performance of the duties of employment. So, to the extent those organizations, by him and by others purporting to speak for that organization, claim to be representing DPS teachers, along with many other missions they do perform, we simply asked, and we were very scripted in our request, that to the extent those organizations purport to be representing DPS teachers, and to the extent Mr. Khan, through those organizations, is purporting to represent DPS teachers, and in his capacity as a DPS teacher, he should refrain from advocating that people violate the law.
Okay. I am going to dismiss those parties, and I'm going to make it very clear as to why. None of those entities, according to the law of the state of Michigan, is a collective bargaining representative and is bound by para. That's the only way you get jurisdiction. You have filed claims also for violation of the revised school code. They're not bound by the school code. Breach of contract, they're not parties to a contract. And intentional interference with an advantageous relationship, count 4. I can't even find a well-pled fact in the complaint that would support a claim against them. If you can find one somewhere and you want to file a motion to reconsider, you are certainly free to do so. As relates to the relief that that you've requested today, which is that we enjoin Mr. Khan individually, until and unless the court has the opportunity to make a fact finding, I don't have a basis to enjoin him from anything. I have received numerous exhibits on behalf of the plaintiff, which purport to be statements made by him. As of this point, without, again, a hearing, they are out-of-court documents offered for the truth of the matter asserted therein, therefore they are hearsay. And if you want to use them as statements against interest, we'd still have a few more hurdles to go through to consider those. The exhibits that were attached, as I said, several of them, they're attached somewhere in cyberspace, but I don't have them. The exhibits that were attached to your original papers were a proposed order for injunctive relief, the affidavit of the emergency manager, and the affidavit of the emergency manager says that it, I want to make sure I want to get the right paragraph. It refers to other documents, and we'll get to those. We have an exhibit number 3, which is an affidavit of Mr. Losey or Lucy, I do not know which. Its contents relate to at least double hearsay, if not triple. The emergency manager, exhibit number 5, is the emergency manager's order, and the court properly would consider that. There is something that says it's a transcript of a podcast from someone whose name is Frank Beckman, which at this point the court could not rely upon to do anything because we don't know on what basis it could be admitted. And there are a series of, it says there are attachments, a January 16th interview, January 8th interview, a robocall, attachment C, which says it's a robocall from Ms. Bailey. I would like someone to please let me see that. I don't have it. A video transcript of Stephen Kahn and a certificate page. The other exhibits, 7, 8, and 9, are all articles that purport to contain statements made, but which again would require some sort of verification. Exhibit 15, similarly, the first, second, third, and fourth supplementals also included excerpts from sources that are not present in this courtroom. In order for us to proceed, even for the request for injunctive relief against Ms. Bailey and the Detroit Federation of Teachers, this court would have to make a finding that there is a duty under para that they have not met. The duty that you have addressed thus far is a duty to prohibit their members from striking, which as a matter of law they can't do. They are precluded from encouraging a strike. And you have inferentially said that they've encouraged it by not discouraging it. And I would ask on behalf of the plaintiff if you would point me to anything, including a Merck decision, that requires that the officers of the collective bargaining unit articulate a particular phrase that tells their members that the strike is illegal if there is a strike. Could you share that with me?
Of course, I cannot share with you a Merck decision, as the court knows full well there is no such decision, but I can cite to the statute itself. And the statute itself says that public employees do not have a free-ranging right to free expression, if that expression or communication interferes with the full, faithful, and proper performance of the duties of employment.
Which still requires an affirmative communication. So could
Correct.
you tell me what communication you are attributing, I didn't know, it's
We
probably
are-
in here somewhere,
in the case
to
of
Ms.
Ms.
Bailey?
In the case of Ms. Bailey, we are relying on the robocall that is her voice that is transcribed, wherein she's advocating that strike may be necessary, and then a later communication from her where she agrees with the striking position of the teachers.
Okay, so
With respect to
you're
Mr.
prepared,
Khan.
you're prepared, I just asked about Ms.
Yeah.
Bailey. I try to do things one at a time. You have a more encyclopedic brain than mine. I want to do it one at a time.
Not at all, Your Honor.
So let's start out with Ms. Bailey. What is it that you have that is competent evidence that you're prepared to present to the court right now?
All we have is all that we're required to produce to this court to show a likelihood of success on the merits to warrant injunctive relief, and that is statements attributable to her. Yes, not made in court. How could they be? They are out-of-court statements made by her. We also have statements by Mr. Khan where they take...
Again, I'm working on Ms. Bailey.
With respect to Ms. Bailey, we have the statements made by her in support of the teachers' collective striking action.
The one
And
that,
that-
let's assume, at best, the language of the robocall says a strike may, at some point in life, be necessary. Is that correct?
Correct.
Okay. That wouldn't get you an injunction here, a call saying that something might be. It's a question of, is she calling for or encouraging a particular strike at this point?
Well,
For
again,
your,
I
for the
understand
purpose,
what-
for
go
the,
ahead.
I hate to interrupt you.
I didn't mean to interrupt you, Your Honor.
For the purposes of your TRO. Now, I assume that you're going to move forward and request a preliminary injunction. Is that correct?
That was our intent.
Okay. So if we're going to have a full-fledged hearing on the preliminary injunction, you may be able to bring something into this court that would make that transcript more reliable, or put it in a different context. The other portion, you said that, the other statement that you said that you find to warrant a TRO is her saying she sympathizes and understands?
That she understands that the work outages are related to the working conditions and attempting to effectuate change. But again, the quality of those statements are no different than the prior one, which you've already ruled wouldn't be admissible for the purposes of injunctive relief in any event. So I don't see any point in belaboring the record with additional out-of-court statements that apparently are not going to be admissible for that purpose in any event. I would also like to direct the court's attention to 423.203, which also says that people in authority, supervision, or any kind of directive control shall not encourage people to strike. And if the union, the exclusive by law bargaining representative of the employees, a union so strong that I cannot talk to the employees directly, I must talk to them. If they are in supervision or a capacity of supervision over public employees, I don't know who is.
I don't disagree that they're under supervision. That isn't what I asked.
Well, their own brief on behalf of Mr. Khan.
Mr. Khan is not the brief on behalf of DPS,
I
DFT.
understand. No, except that.
Excuse me, Mr.
Okay.
Butler. I'm dealing with I started out with Ms. Bailey as the current president of the collective
Yes, I
bargaining unit.
understand.
Then I'm going to the collective bargaining unit. I want to manage that issue. Then we will hear from your colleague in that same regard. And then we'll go on to Mr. Khan and whatever it is you have that you want to present in that regard.
You have everything before you that we are capable of presenting at this time, including, yes, statements made to the press by individuals purporting to speak for the teachers. And the only reason I raised Mr. Khan is that he claims to represent a union within the
I could
DPS.
claim to be the Queen of England. It wouldn't make me the Queen of England.
It would if you were a public employee making that claim.
No, it wouldn't. You find me a case that says that because someone purports authority, even though
No,
they
no.
are not in that authority, that they have it.
That's not what I'm saying. I'm saying he's acting at all times as a public employee.
He is a public
And when he himself
employee,
does
yes.
not take off work, but causes others to do so, at great exposure to
Again,
themselves.
I'm still not at Mr. Khan. I understand that that really is the focus of your inquiry
No, not solely.
at this point. But right now, I want to talk about the collective bargaining unit. So
Yes.
you've shared everything that you have about the CB.
You have everything before you
Okay.
that we have here.
I understand. On behalf of DFT and Ms. Bailey, I have not, what, if anything, did you want to say relative to the state of proofs for a TRO only?
Your Honor, I think the proofs, Your Honor, I think that the proofs are completely deficient. I would like to state that I will be speaking with Mr. Butler after this hearing and seeking his concurrence in either motions to sever and or dismiss many of the defendants. I greatly appreciate your clarification and distinction between the defendants because I think that the plaintiff is trying very hard to merge them inappropriately in the context of due process and injunction hearing. Thank you.
Is there anything else you would wish to say relative to the collective bargaining unit and its acting president?
Nothing other than to hand you the exhibit that was filed with the papers of the.
Okay, if you could,
Which is the transcription of Ms. Bailey's statement to all all DPS teachers.
I will tell you that that all of this stuff was available online, so I got a chance to read it. When I asked for the hard copies, I did not get it. So I did have the opportunity to read that which you presented. I'd highlight, assuming that even if this is accurate, the statement that I was given, the DPS message text, I thought I remembered this, says, quote, in pertinent part at lines 19, we may have to do a district-wide work stoppage or strike action, but we must be united and we must honor the democratic rights of all members with a secret ballot strike authorization vote. That to me would indicate that while she may have been encouraging something, that the thing that she was encouraging on January 14th, there has been no such, apparently, that I have it, vote to authorize a strike which would be illegal under para. And the court is not prepared at this point to enjoin temporarily either the union or its acting president, Ms. Bailey. The matter will be scheduled for a hearing on a preliminary injunction, and we'll take care of that matter once we come to the conclusion here. Counsel, relative to Mr. Khan, on behalf of the plaintiff, you wish this court to enjoin Mr. Khan, and you make whatever argument you think is appropriate and most compelling in that regard.
Well, as indicated previously, Mr. Khan is first and foremost a public employee. He's a DPS teacher. He has repeatedly called for collective action, not only for them, but has taken credit for them as they've occurred in the various statements we have attached. Again, those statements are only things we can go by as being statements of him in the press, but now we also have his brief. And his brief is replete with statements wherein he not only takes credit for calling and orchestrating the strikes, but also attributes that the reason for the strikes, in addition to apparently being in solidarity with his effort to get his job back within the union, and in solidarity with his dislike of the current gubernatorial administration and the laws the legislature has passed, that it is also to protest deplorable working conditions, and that in protesting the government, he is attempting to effectuate change to the working conditions. Notably, I would say for the record, Mr. Khan, while others have followed him and put themselves at risk by taking unauthorized work absences, has himself protected himself from such a claim by calling upon others to do that, knowing he would not be in jeopardy himself because he did not engage in the outages or would wait until buildings were closed that might have affected him before himself taking any action. But he has definitely represented himself to represent a union within the union. That's exactly how he himself characterizes it. And he claims to be a representative of the teachers engaged in the collective actions. And as such, as a public employee, he is openly and defiantly violating the law, and doing so apparent in full apparent confidence that there will be no consequence to him in doing so, because he himself has not put his own job at risk by taking any time off, but rather, in his capacity as a public employee and alleged representative, is calling upon others to do that for him. And that is all we have.
I understand. In response, Mr. Driver?
3 points, Judge. One, we think that the evidence that has been offered by the plaintiffs is deficient. It's hearsay. It's evidence that certainly is not competent to be used for the issuance of a temporary restraining order. There is nowhere in this brief that Mr. Khan, I understand that the plaintiffs are very tied up and very, very, very concerned about Steve Khan. But despite their passion to get him and get rid of him, there's nothing in the brief along the lines of what they're suggesting. Beyond that, we think two things, Judge. There are two lines of cases that we think apply to this. The first are free speech cases, and they're free speech and free association cases. And we think Patterson, NAACP versus Patterson, and NAACP versus Alabama, and I can get the sites for those for you, Judge, mean and stand for the proposition that you cannot be held, you cannot be dragged into court and enjoined or forced to be silent because of your association with an organization and your exercising of your First Amendment rights to free speech and free association. And the second line of cases that we think is relevant to this is that public employees speak out all the time, and in many different places and many different arenas concerning issues of public importance. And they cannot be disciplined for that, enjoined for that, and that is what the plaintiffs are proposing here. None of this falls under the aegis of PARA. If the district is seeking a preliminary injunction against Mr. Khan, we think that they will fail at being able to get that injunction because we think that they cannot present a reason to regulate his speech, which is a compelling state interest, and they cannot show that what they're proposing is narrowly tailored towards that end.
Thank you. You were telling me that I should be able to find admissions in the defendant's brief, and as you know, you've had it a little longer than I have. So could you point me to what I should be focusing on, please?
Well, again, not knowing who they speak for, when they make statements like the tactic of teachers calling into work to express their opposition.
Again, counsel, you're drawing my attention, so you want to tell me where you're reading
There
from.
are no page numbers. This is the second physical page of what I was given, which had no exhibits, by the way, just text. Which
Okay,
is fine.
I'm looking at the second page. Yes, sir.
First full paragraph, midway down, the tactic of teachers calling into work to express their opposition to the Snyder Plan and to change the balance of power was reinitiated. At first, the sick-outs seemed uncoordinated and spontaneous, but as the struggle advanced, with Governor Schneider refusing to budge, coordinated days of mass action were needed to raise the struggle to a higher, and then it doesn't say what, to a higher, period.
Okay.
BAM and the Strike to Win Committee took the lead in organizing. And again, Mr. Khan purports to be a representative of BAM, a representative of the district, a representative of district teachers. And that's all I have. I mean,
Okay.
there are other statements in there that make it clear that this is as much about working conditions, the third physical page, the appalling conditions of third physical page, second full paragraph. halfway down. The appalling conditions of the schools, denial of basic educational essentials, et cetera, those are all relating to working conditions.
So things that relate to the children's supplies relate to the working conditions of the teachers? Okay.
Para addresses taking collective action to effectuate change in the working conditions, terms and conditions of employment, everything relating to employment. And, talking about a lack of supplies, et cetera. I'm not taking issue with statements as to whether that's true or not. What I'm saying is if that is being used or others are being encouraged to believe that those types of issues are justification for striking, they are not, as the law makes crystal clear. Whether, these statements can be attributed to Mr. Khan, whether these are positions in theory he's advocating, or whether he himself is saying this is why we're striking, I leave to you to make that determination. It's absolutely crystal clear in my mind.
Okay, and I appreciate that, but
Yep.
beyond the words you pointed me to,
Right.
there's no place in here where I'm going to see an admission or a paragraph or a sentence that begins, Mr. Khan said to do X, or Mr. Khan coordinated Y. Is that fair?
Brief, no, but in the exhibits to our
In the exhibits
motion,
that,
yes.
yeah, okay. And again, if we had some way to authenticate them, and find them reliable, we'd be in a different position, but we do not as of this moment. When the court, when the court made the parties aware of the date and time of the hearing, one of the inquiries made was, do you have any witnesses? And if so, because we knew we didn't have room for them, we made it clear as to where we put them so we could have brought them in. I assume that at this point in time, on behalf of the plaintiff, the witnesses you would need to authenticate those documents were not amongst the other district employees that you were able to marshal in this short period of time. Is that fair?
Yeah, I cannot, none of the representatives of the administration can authenticate
Right.
a statement by Mr. Khan. Only Mr. Khan can do that.
Well, actually, no, and you and I know that if it's a statement that was made to another individual, that individual could do it as well. And what I did not say that you didn't know who could do it, I said that as of today, with this short period of time, the persons whom you brought were the persons who were principally the agents of the plaintiff.
Correct. And
Okay.
we, short of, for example, in the Frank Beckman interview, short of subpoenaing Mr. Beckman himself, who again could only attest to what he recalls being told by Mr. Khan.
Which is an admission against interest. So
may
it
well
would,
be.
it would, of course it
But Mr.
is.
Khan can authenticate those as well.
I'm sure he could. But as the party bringing the motion at this point in time,
Well, but he's been noticed to be present here today.
and
I don't know if he is or not. I do not represent him.
I have no idea. Let's assume he is here. Then what would you do?
Then he can corroborate that he made those statements, presumably. How would he deny them if they were
So,
quoted?
I don't know what he could do, sir. You've not asked to call a witness. Anybody. I asked you, what did you have to present? And you told me that all you had was that. You didn't say, well,
short
Your
of
Honor,
calling witnesses,
pardon
that's
me.
right. That's correct.
I didn't say short of calling witnesses. I said, do you have anything? So are you telling me, sir, at this point in time, that you have a desire to call a witness whom you think is here? I don't know.
On the issue of corroborating Mr. Khan's statements, the only person I could call would be Mr. Khan if he's present today.
And?
And I assume he is because he was notified. But
And you're, what?
He's a part of it.
Okay. Are you requesting that Mr. Khan be called as a witness?
If the
That's what I'm
court's-
trying
if the
to
court's
ask.
indicating that they will not accept statements made
I
not
told
of
you I
court by
wouldn't.
him, then yes, I would call him to corroborate those statements.
He would like to
Whether
call
that
your
would be
client?
today or later.
Pardon me?
Mr. Khan is not obligated to make the plaintiff's case for them. He's not obligated to be available and to testify at
Counsel?
their discretion.
No, and no one said he was. Your colleague said he wanted to call him as a witness. I have no idea, and I'm probably the only person in Detroit who can say this. I don't know what Mr. Khan looks like. So I don't know if he's here or not. I do not know if, and if your colleague wants to call him as a witness, there would be no prohibition against that, assuming that he was served and properly noticed. I suspect neither was exactly true, but that he did in fact get served through you. Is that correct?
That's correct.
That's actually not, he was served.
Okay.
The return of that service is to the public court.
Let's see.
Not-
Henson, Jones, Conaway, Russell. Okay, it appears that Mr. Khan accepted service on behalf of some DBAs, Detroit Strikes to Win, well, okay, here we go. He accepted service on 1/22/2006, and that was service of a summons and complaint telling him he had 21 days to file an answer. So actually, that doesn't necessarily mean that he would have to either be here today or be called as a witness.
Just for the
However,
record, he was served with all the pleadings filed through that date and a notice of appearance for today.
okay, and the summons and complaint and all of the addendum informs him that he has 21 days within which to file an answer. He wasn't served with anything that, was he served with an order to show cause why he should not, and to be physically present? I don't know.
We only issued the notice that we were directed to issue. We were told that the notice to come here today, beyond what we notified each person of, would be issued by the court. I have never seen that notice, so I don't know. But we notified him that there would be a show cause here today.
Okay, so I assume that what we need to do is to set a hearing date for a preliminary injunction. Are you possessed of your calendars, counsel?
Yes, Judge, can I ask one thing, however? We would want the opportunity to brief the,
You're going to have an opportunity to brief so much, it's going to make you terribly happy. Okay.
or at least keep me up at night.
One of those.
Your Honor, if I may.
If we were to,
I just don't want to have people incurring unnecessary legal fees, especially in light of the fact that we are going to be talking some sort of hearing. I would stipulate that with respect to Mr. Khan, my only complaint against him would be that to the extent as a public employee he was encouraging other employees to strike. I know he did not miss work himself as a striker. I know that. So I want to make that very, very clear. So I'm not, I mean, I understand that in order to prove that about him beyond the statements attributed to him, I have to call him as a witness to do so. But I would rather, while that would be necessary in accordance with your ruling, I would rather hold off making that an absolute necessity until we've had a chance to talk.
gosh, it seems like you guys have had a lot of opportunities to talk before you got here, but I'm going to
Not
give you a
counsel.
period of, well, The only thing I was really sure of is I knew who the counsel of record was DFT, and I knew that Mr. Khan was represented by Ms. Driver, even though I can't tell you what he looks like. That I knew, and I knew nothing about this case. I am looking to give you 10 days within which to do the following things. Determine and subpoena whatever witnesses you think are appropriate for the preliminary hearing, but also to brief the question of whether or not the activity that is the subject of this proceeding is an activity which is a strike as defined by para, the extent to which this court has jurisdiction over this activity, and whether or not the additional claims in the complaint, including such things as, I'll just cite them precisely because I don't want to ask you to do something that isn't very clear. Your claims for violation of the revised school code, intentional interference with contract, intentional interference with advantageous business relationship, breach of contract, are claims for which this court, rather than the Michigan Employment Relations Council, Commission rather, has jurisdiction. I am looking then to receive whatever papers you have on that issue, including motions to amend or strike pleadings and motions for summary disposition by February the 8th. I would schedule the hearing for February the 12th.
Judge, I will be in Los Angeles for another case.
When are you going to Los Angeles?
I'm going on February 9th.
February 16. The other case, how long is it?
It will be concluded by then.
Is there a reason why any of the council cannot be present on 2/16 on behalf of the plaintiff? No, sir?
Oh, good.
Okay, I was hoping, I wanted the record to actually hear you, so.
I'm sorry.
That's
I'm sorry.
okay. On behalf of the defendants.
That's fine, Your Honor. Thank you.
Okay. I would encourage you to have some conversation, and I would require you to visit with me and have some conversation. I want you to talk to each other first, because you'll probably be more productive than a conversation with me initially. Is there a time on Monday that you're available on behalf of the plaintiff and defense? Just to come and talk to me.
Your Honor, I'll make myself available that date anytime you need to the court.
Ma'am?
And I can give that back.
Okay, 2 o'clock. At that point, I'll be able to tell you what courtroom we'll have and whether we'll be in Coleman A. Young or whether we'll be in Frank Murphy for the actual preliminary injunction hearing. I suspect that we will be in Coleman A. Young. The courtrooms are smaller there, but there are 2 that are not currently being used. The court would therefore, at this point, decline to authorize a temporary restraining order, finding that the court is not in possession of proofs with sufficient content and reliability upon which to find that either Ms. Bailey and the Detroit Federation of Teachers have encouraged violations of para, or that Mr. Khan has breached his duties as a public employee under para. We are in recess.
All rise.